All right, Chaz. So one of the two plaintiffs, at least the two they have so far in this lawsuit that's been filed against Pizza Hut, involves a former Schenectady delivery driver. He was there for, I think, like 7 years, from 2005 to 2012. And there's this question about the, I guess Pizza Hut has a $2 or something delivery surcharge, and the plaintiffs are claiming that that appears to be to the customer a tip when it's not a tip, and they're being denied potential tip wages. So first of all, is there any sort of disclosure requirement that Pizza Hut would have in New York State to let the customer know that there's a $2 surcharge for a delivery of a pizza?
Well, I don't think there's any legal requirement that they disclose it. It's something that they usually let you know if you're going to get food delivered. That's a service, and it comes at a cost. I think the bigger question in this case is where does that delivery surcharge go? The impression, at least the argument is that the impression the customer is left with is that it's going to compensate the delivery driver, presumably for gas or wear and tear on the car, or it's a part of their wages. And I think that's the argument in this case. That the delivery drivers are saying, well, we're not getting any of these surcharges back, and therefore people are tipping us less, and the employer is keeping this surcharge. It's essentially part of our tips, or should be part of our salary, that we're not getting. And then when you calculate it all of it together, as a result of that, we end up making less than the acceptable minimum wage in this state, and that's where you have the basis of the case here.
Well, maybe this goes back to my disclosure question then, because where would customers be getting the idea that this is going to the employees when it's not?
Right, and I guess that's a factual question. We'll have to see as the records develop, what comes out. I don't know that that's the case. That's the argument being made by the delivery drivers. If you ask 10 people who got their pizzas delivered, they may tell you, no, they understand it's just a charge for the service, or they may tell you, no, we all believe it goes back to the delivery driver. So I don't know, until the records develop, if that's actually the case. That's the argument being put forth by the delivery drivers, that people are under that impression. Whether or not that's actually true is a factual question in the case that's been brought here.
I'm guessing by and large that, and I don't have much experience either really frequenting Pizza Hut and certainly having a pizza delivered by them. I'm not a Pizza Hut type of guy, so I'm wondering if there's any, if you're looking at a takeout menu and you want to get a pizza delivered, if they state that clearly on the takeout menu. Because to me, if you tell me $2 surcharge, or if I see it, at least as far as my impression goes, I'm thinking that's not going to the delivery driver when I see that, a $2 surcharge.
You're thinking it's not going to the delivery driver?
Correct, yeah. I mean, wouldn't that be the argument that Pizza Hut could easily make in court if it goes this far?
Yeah, and I think that's exactly the argument you'll get on the other side. I think what it's going to come down to, and we saw a similar case or something, at least in the same realm, with Starbucks recently. There was a class action there where you had their baristas or their management trying to participate in the tip pool, that the hourly workers were getting there, and you had a class action suit, and what the hourly workers were saying was, look, we've got management taking our tips or taking a portion of our pay. And when you look at it after the fact, we're now making less than minimum wage. Same thing here. You have the pizza drivers who are saying, look, we've got management or the company taking a portion of our pay. In this case, it's the $2 surcharge, not the tips. But the argument is essentially the same. And if you use the Starbucks case kind of as a measuring stick, that case just recently settled for, 7 figures, and there was a determination that, management shouldn't be taking a portion of the tips, and it's improper, and there is a misimpression there, and that as a result, the hourly workers were not getting paid enough. Is that going to be the same result here? I think a lot of it depends on what's developed factually in the record, whether or not people are actually under that impression, how much do drivers actually get paid, and, what percentage of the tips are or are not affected by this $2 delivery surcharge.
Right, and I wonder, too, if there will be some sort of record of tips versus wages. You're supposed to disclose the tips you get, although we know that sometimes that doesn't happen. So,
yeah, it'll be an interesting case. But like I said, if the Starbucks case is any indicator, that just wrapped up, I think, for $14 or $15 million. And there was a finding there that the hourly employees were losing a portion of their tips over several years. So if the court determines here that the $2 surcharge is something that should have been going back to drivers, or it should have been more clear that it wasn't going back to drivers, then you may end up with a large settlement in this case too. Or you may come to the conclusion that there's no confusion there, that everybody knows that's just a cost of the service. It has nothing to do with gratuity if you decide to give any to the driver or not, and there is no case here. So, until the record's developed a little more, it'll be interesting to see where it goes.
Yeah. How would you expect the plaintiff's attorney to use the Starbucks settlement as kind of a precedent here and piggyback on that for their own case?
Yeah, I think it's something you can certainly cite to and look for comparisons. And, there are certainly different laws at work in each of the cases, different statutes, but it's certainly something that you can draw parallels to, take a look at it, and even in my mind when I'm looking at it for the first time, as I'm looking at this Pizza Hut case, the first thing I'm thinking of is this recent Starbucks case and how there are some similarities there, and if I'm on the other side advocating, I would certainly try and draw parallels there.
Yeah, now they're also looking for class action status, and does that speak to the number of plaintiffs? It sounds like they want this to go national. Right now it's one plaintiff here in Schenectady, another in Syracuse.
I think that's the only way that a case like this becomes viable, because if you're talking about damages for one delivery driver, even if it's over a couple of years, you may be talking about a few $1,000s or maybe tens of thousands of dollars. But to really make the case economically viable, you've got to do what they did in the Starbucks case, which is get a class certified and really bring in a ton of plaintiffs so you can then exponentially multiply those damages and actually have a viable case, a case that, really becomes one that's worth pursuing.
And that class action is defined as number of plaintiffs or number of states involved?
Number of plaintiffs who all have kind of a similar case or similar interest in order to get it going. But before you do that, you really need one plaintiff to get the ball rolling, and I think that's what they've done here.
Yeah. How many plaintiffs would they need, do you know?
It's not. It's different for each case. You got to apply for class certification in federal court, and it all depends upon the type of case. So it can be a couple, it can be hundreds, it can be thousands. It all depends on, how many people have been affected here. So I think right now they're trying to build the class. There's some ads out there. They're looking for other potential plaintiffs to join in on this. So we'll have to wait and see how many they are able to gather up.
Okay. Also, now, would it make it more difficult for Pizza Hut to argue, like, say, if they want to try to take this to a summary judgment? Oh, well, this is just a disgruntled employee, or in the case of two disgruntled employees, if they have class action, does that make it more difficult to make that argument legally?
Yeah, I think when you start getting, a dozen, 2 dozens, or if you start to prove that this is a company-wide policy that's affected hundreds or thousands of drivers, then it's not one disgruntled employee, 2 disgruntled employees, then it's a pervasive pattern or a pervasive policy that has affected thousands of people and, resulted in who knows how many dollars in lost wages. And I think that's really where, like I said, a case like this becomes viable if you can kind of get it to reach that point.
All right. Chaz, thanks a lot for your time. I appreciate it.